Hi, Ruth. Just so you know, at the moment we can see your slide and then the next slide as well with the notes. Now we just see the slide. It looks good. And if you happen to be talking, you're on mute.
Okay, we'll try this again. Can you see my screen with the slide presentation?
We can see it.
Perfect. Okay. Again, I'm Ruth Pack-Adler. I'm a member of the Ohio team here at Abnauer Weicker, and I primarily work in our special education spaces, but I also help support our students who find themselves in criminal matters in the courts here in Ohio. And so that brings us to our topic today of school-based threat assessments. Last year, Megan and I did a presentation on the social media aspects of education law and how that was kind of changing the landscape for lots of our students. And we touched on some of these topics then, but there's enough information now, and it is so critical to our practice that we thought that we would bring out an entire presentation on threat assessments because it's something that we're seeing more and more throughout the K-12 space across lots of types of schools, private school, public school. This all arose, as you probably are all aware, about 26 years ago. When we talk about school threats, we first look at Columbine. And Columbine, 1999, followed by many, many more horrific school shootings, massacres, Sandy Hook, Marjorie Stoneman Douglas. Last year, we talked about Oxford and Uvalde. When you look up some of the statistics about mass shootings at school, the numbers are different because there are lots of ways to classify these depending upon the time of day and the location and things like that. But the bottom line is 500 people have been killed in school shootings since 1999. And that is what we look at when we talk about what is happening in the space of threats. Everything is done with that framework behind us of preventing the next mass tragedy. So we look at what is a threat. A threat is a communication or an intent to harm someone. How that's communicated doesn't matter. It could be spoken out loud, it can be written, it could be a gesture. We're going to see some case studies later where some of these are highlighted. It doesn't matter the form, just that it is delivered to someone or someone hears it or overhears it. Again, it could be implied from behavior. But lots of things are going on right now in our kids' lives, right? They chat on social media, they text with one another. They are constantly living in a communication world that we did not live in as students, but all of that is communication. And all of that and the content of those communications could be deemed threats, regardless of whether or not someone intended to actually follow through. It doesn't matter if the plan was in place. It doesn't matter if it was said in the moment. Threats that are easily conveyed to someone else will be taken seriously in light of this backdrop of mass shootings. One of the things that kind of is the segue here is underlying all of this is preventing that next massive tragedy. No school wants to be on the news with one of these instances of a mass tragedy situation. But the reality is today that schools are dealing with what we would call threats daily. There is never a time that I've spoken with a school administrator that they haven't said that they are working through these types of scenarios every day for their students. There's kind of a lag in my presentation. You should be seeing a screen that says Ohio's laws and procedures, but I don't believe you are.
Try to click one more time, see. Jessica had this issue earlier. Maybe if you stop sharing and share again.
Try this one more time.
And we
You
still
see
see
the
what
one
is
is a threat slide.
Okay, it just went forward on mine. See, Jessica, it's happening to both of us.
Yeah, you can go to whatever slide that you want to start at and then play from current slide.
Yeah, we're trying that. On my screen, I see it says Ohio's laws and procedures.
If you want to, I mean, we can see each of the slides. I mean, we see the whole program. If you want to continue from there, I can try something in the meantime. Well, if you just want to,
You want
Go
me to
with
stop
it.
sharing, Mark?
yeah, just you can go ahead with your
Okay.
presentation. Yes.
Slide 3 is Ohio law and procedures. When we talk about school threats, there's some generalities that match. This is based on a national program that was designed. Dr. Dewey Cornell years ago wrote the Comprehensive School Threat Assessment Guidelines, and many schools across the nation will look at these comprehensive guidelines in creating their specific laws and procedures. In Ohio, we only go back to 2021 that we created the Save Students Act, Safety and Violence Education Students Act. There's not a lot of teeth here. What it does is it requires schools in every building with students grades 6 through 12 to assemble and train a threat assessment team. That team can follow its own procedures, can choose to act how they want to act in assessing threats. That team should be multidisciplinary in its makeup. The law requires some annual training after an initial training. That training is given free. Michigan and Pennsylvania have similar requirements. It's all again modeled after the CSTAG training, CSA Comprehensive School Threat Assessment Training Guidelines, and we'll have that information for you at the end. I have attended the school-based one here for Ohio. It's a day-long training. I was the only non-school personnel person at that training. I found it to be very instrumental to my practice because it gave me insight into how those teams were working to assess threats. Thank you for sharing that, Mark. I appreciate it. So the teams get together and they should contain different members of a school-based team. A threat comes in, a threat is relayed from a student, somebody hears about on social media. The team gets together and they start talking about the student. They start talking about the threat. These teams can be administrators, school psychologists, teachers, counselors, school resource officers. They need to be involved in this decision-making process. The interesting thing is we have seen threat assessments take hours of a school's time. A really comprehensive threat assessment that follows those model guidelines and forms can well take 2 to 3 hours to complete. They look in lockers, they look at students' search histories. They do some kind of deep dive into who knows this student, what do we know about them, how have they been in previous years, have we noticed anything new about them this year, any concerns we should have. And then we've also seen, and we will see a case study later, of some really poor threat assessments. We're going to go on to the next slide. And we'll talk about one here. CT was a student of ours. She was after school, 13-year-old girl, went with her friend to a chicken place near the school. The girls sometimes rode the bus home from school, but on some days they had parents' permission to go to this chicken place and hang out. And they were hanging out that day, and CT's friend left her keys in the booth. So she quickly texted CT and said, hey, can you bring my keys to school tomorrow? CT said, fine. And it's hard for me to describe what this looks like. You guys can Google it. If you have teenage daughters, you may know. This keychain has everything attached to it. It's got a big colorful pom-pom, and it's got lip gloss, and it's got keys. It has a packet for tissues, and it might have some self-defense items in it. There's one little device that you use maybe to poke someone's eye out if they get close to you, or pepper spray. Unfortunately for CT, hers had pepper spray. Pepper spray is deemed a weapon. The next day, CT comes to school and she gives her friend back her keychain. And unfortunately, the pepper spray part has come loose in CT's bag. CT has this, it hasn't sprayed or anything, but it's in the bag, and CT makes the poor choice of saying, hey, your pepper spray is here in the classroom, when giving this back to her friend. CT and her friend are brought down to the office and no threat assessment is undertaken, though this is a violation of the school's code of conduct policy. CT, unfortunately, because there is a zero tolerance now in light of Columbine and all of the serious threats, when weapons are on campus, expulsion is on the table. Luckily for CT, this school was not looking to expel her. They understood she made a mistake. They brought her in. We had a hearing before the superintendent. Her entire catalog of dumb write-ups, disrespect, tardiness, unpreparedness came up in that, but there was no concern that CT posed a threat. She found that she had this pepper spray on her and she didn't intend to use it. She didn't make a threat toward anybody that she was going to use it. She just wanted to get it back for her friend. I put in here that CT was also a star athlete, though she is young. She played both for the middle school and the high school on the basketball team, and we can decide whether or not that mattered that CT not be expelled. because they required her to be a starter on her team. But good for CT, no intent to cause harm here. She comes back to school the next day with a strong talking to. That's a positive. Let's go to the next slide, Mark. So threat classification levels. I've put these 4 here because these are what are outlined in the CSTAG training: low, moderate, high, and imminent. Again, because there is no requirement to follow a standard policy, we see districts use classifications all over the place. Some have 3 levels, some have 4 levels. In the CSTAG training, one of the keys is that a transient threat. Is this person making a threat against another because they're mad, because something happened and they're showing some kind of impulsivity? They have no intent to act. It's just an expression from a young person who is immature and doesn't have a good way of explaining themselves. So transient is something that we come to a lot of times with the districts that follow through on CSTAG training. And this is what we often would like to see, is a real thoughtful consideration by that threat assessment team of what's happening here. When you take the training that the state gives, the real thrust of it is what's next, right? You're dealing with this crisis in the moment. A student has made a threat. Student has brought pepper spray to school. How do we deal with it? And what do we need to do to support this student going forward? So in CT's case, she was brought in, she had this really uncomfortable expulsion meeting. Her kind of crummy school behavior was brought in front of her parents, and I think CT even brought her grandma and her pastor to that meeting as support people. But the school felt like she learned her lesson, and there was nothing more that needed to be done for CT to learn this lesson. You know, as an aside, we talked about what could happen. A lot of parents in this district felt unsafe having their daughters walking home from school without pepper spray or the little poke you in the eye tool on their keychain. But if they bring it to school or bring it on a school bus, it will be a problem. The school, when we posed that to them, said it could be checked into the school. Again, that doesn't solve the bus problem. They can't have it. But if a student is leaving campus in the afternoon, the parent would need to make arrangements to get that to the student off of school grounds if they felt that their student needed it for protection off campus. It can't be had on campus. So again, what happens next is always the question. You'll see that we have suspension expulsion hearings. We talked about manifestation determination reviews. We'll touch on that a little bit later on. Behavior support. Earlier this morning, we talked about a functional behavior assessment. Oftentimes, students who are identified as making threats need more support at school. These students could be special education students, but they don't necessarily need to be. Mental health is a big piece of this. If a student doesn't have a special education plan, if something that is perceived as a threat is deemed to be a concern for that student's mental health, are they being bullied? The school needs to react. After assessing the threat, the real work begins for that student to support them, to keep them at school and safe, and to keep the rest of the school safe. Let's go to the next one, Mark. Students with disabilities. I know we already touched on this. When a student makes a threat, oftentimes expulsion is usually on the table. That is just because of the zero tolerance policy for concerns of violence at school. If that proposed discipline will take a special education student out of school, out of their least restrictive environment, or as we heard from Renee, off the bus, they've done something on the bus, we get to the manifestation determination review. And I guess this is a plug for my presentation tomorrow. We'll talk all about manifestation determination reviews. Essentially, what we're going to do when a student with a disability has made a school threat, We're going to first make sure that when we're doing our threat assessment, that we adapt that threat assessment for this student in light of their disabilities. Oftentimes, the first step for a school with a child who makes a threat is to bring that child in to talk with an administrator. We need to make sure that that administrator is aware of any disabilities or disabling conditions that may make that child more vulnerable, that may make that child miscommunicate things that a non-disabled child would communicate better. We also need to make sure that if any behavioral concerns have already been called out for this child, that we're taking those into consideration. Students with disruptive mood disorder or oppositional defiant disorder, when cornered after making a threat, may need more support in the moment. Many parents, their go-to is, you can't talk to my kid without me being there. That is not true. When the school has concerns for a threat of violence or safety, either for that student or for anybody else, they have a right to speak to your child without you being present. They need to make sure the school is safe. Oftentimes they will call in the school resource officer. Usually it's as they're calling the parents, but in almost all of these cases that a school is taking a threat seriously, the parents will not be there when the students are first questioned. And that's okay, because hopefully the school's going to do a good job and do a good write-up of what they have understood from this student. And there's going to be due process rights allowable when the student is going to be recommended for some sort of discipline post making a threat. We always want to make sure that a staff member with knowledge of that student's disability is part of that threat assessment team. That's going to be critical here, because if the threat assessment team is not familiar with this student, they may not be able to understand the nuance of the threats. And we'll get to that a little bit later in some of our case studies as well. So let's go to the next one, Mark. So JR has obsessive compulsive disorder. JR was an 11th grade student at the time at a large suburban district. And JR was under the mistaken belief that a girl he thought was his girlfriend, she was not, was cheating on him. And JR decided that the only way he could find out for sure whether or not she was cheating on him was to go into her classroom. Now, I want you to put yourself also in the mind of the teacher of this classroom. Large suburban district. This teacher has never seen JR before. JR bursts into the classroom, screaming at the girl to give him her phone, and she doesn't want to do that. The teacher is cowering. She doesn't know what's going on. He is very escalated at this time. The young man and the girl get into an argument about the phone, and he proceeds to pick up her computer and her phone and throw it to the floor. At the same time, the teacher in this classroom, in a panic, picks up her own cell phone to start and text the administrator, something's going on, you need to get down here now. And JR walks up to her and smacks the phone out of her hand and then barges out of the classroom. In the hallway, he kicks over some garbage cans. I'm sure he's screaming or mumbling under his breath. It's unclear what happened in the hallway, but most everybody in this corridor of the school knew that something was going on. JR was charged under a number of code violations at school, and we first went to a manifestation determination hearing. And at that manifestation determination hearing, it was found that his behavior that day, the code violations that he committed, entering the classroom when he shouldn't have been there, assaulting the teacher, disrupting the classroom, all of those things, destruction to property, all of those were deemed manifestations of his disability, and therefore he would not face exclusionary discipline at school. This case is an interesting one because what happened at school enabled JR to come back, but we had a teacher in a complete panic. We understood that this was not going to be a good situation for JR if he came back. And we entered into an agreement with this school that JR would be able to attend school in a different one of the school's buildings. It gave him a chance to kind of distance himself from this outburst, and he went back to school with more support under his plan. They did a functional behavior assessment to understand what was going on, and JR was much more supported at school. But then you will also see here at the bottom, felony and misdemeanor criminal charges. The school-based threat assessment was the first one I had seen that followed the CSTAG guidelines to a T. This is one that took them many hours to complete. Locker searches, library searches, talking to his parent, talking to him, talking to people who knew him. Very comprehensive and complete, and it was deemed a credible threat, right? This classroom teacher was in a panic. He was angry. It was disruptive. Was he threatening to do something to the school? No, but he was threatening to do something to this girl, and his smacking that phone out of the hand of a teacher was also an assault. So long story, we just wrapped this case up yesterday. He had 2 felony charges against him and 3 misdemeanor charges. The teacher sought a criminal protection order, and she was granted that criminal protection order. He admitted to 2 of the charges, a felony and a misdemeanor, in exchange for the other charges being dropped. And he has spent about the past 8 months trying to comply with the many orders of the court to show that he has learned his lesson. Yesterday, the charge that he admitted to, the felony assault of the teacher and the misdemeanor criminal charge, were dropped. He has shown that he is compliant. The magistrate was certain that he is on a good path. He will be returning to school on the main campus in the fall, and we hope that he's going to be successful. But this is one of those cases where not only was it a threat, it was something that was happening that they had to do. The takeaway is, what's next for JR? How will we support him as a student? And Danielle, our advocate, has been working with this family and working with the school so that we think that JR is on a better path, partly because of what he learned in court, that this hopefully won't happen for him again. And if he does find himself in the throes of a moment where he might make some bad choices, he has other opportunities to seek out people at the school who he can go talk to instead of, going down the path that he went down. Let's go to the next one, Mark. TK. TK is one that we see a lot. We've talked a little bit about social media. Bunch of 5th and 6th graders, maybe the entire 5th. Oh, TK, sorry, I got ahead. TK, 7th grader. 7th grader texting, making lots of threatening statements to a number of students at the school. Didn't come to light for a couple of months. When it finally came to light, and in the course of the investigation, it was also uncovered that TK had previously put a knife to a girl's throat after hours on school property. So this is one of those cases where that's definitely a threat. That girl's, life was potentially in danger, but we're now some months after the fact. TK had a 504 plan that addressed his ADHD. So we took that into consideration when we went to his expulsion hearing. And we looked at the nature of TK's threats. TK, in his text messages, which started this all, was using some very strong language that was concerning enough that the school really didn't want TK back on property. He was threatening to harm people, to beat people up, to kick people's rear ends. He was really being a bully and a menace to them. And the school handled this by expelling him for the rest of the year. And that was a number of months. Okay. TK still needs support. TK needs a plan in place that's going to make sure that he doesn't do this in the future. The one thing that's different here is TK was in a district that didn't do a threat assessment. They saw enough in these text messages. They talked to enough people about, their interaction with TK that they just decided to expel him. In this case, we believe the school did a good job. We had a manifestation determination review hearing. The interesting thing is ADHD might make a kid impulsive, might make a kid say stupid things, but TK had a pattern of threatening people over and over and over again. And these were not like one-off statements. TK engaged in text message exchanges and intimidation that went on for 40 text messages. So relying on his ADHD was not going to get him out of this. And in this case, the school kept him out through the end of the school year, but also asked the family to get him into counseling as a condition of getting him back. The knife was an interesting wrinkle on this because not only now are we dealing with perceived acts of violence, but that sounds like a pretty big act of violence. This district did not report TK to the police, so he avoided having any criminal charges filed against him. It remains to be seen if TK is going to be successful when he's back at school. This is just one of those cases that kids don't realize that these social media chats back and forth, the Snapchat pictures, the text messages, they all have a life beyond that moment when they're sent. And for TK, he's out of school, and he might be out of school a lot longer if the school thinks that he still poses a threat when he comes back in the fall. He's really going to have to be on his best behavior to be back in school and be successful. Let's go on, Mark. Okay. This is just a guide for how to make sure that when we're doing threat assessments, we're doing them fairly for everybody. Parents should ask for any documentation that a threat assessment was done. We in our practice always ask that. Did the school do a threat assessment? Again, because it's not required and the format of filling out a threat assessment isn't codified anywhere, we have districts, many districts that don't do them, but it's always a good idea to ask, did you do one? And how did you determine that what my child did was a threat in this case? The knife, I think, speaks for itself. The pepper spray, a little bit different. Was that a threat or was that bad judgment in bringing something to school? We just got a pop-up. I think I've mentioned this a few times. True or false, schools are required to follow a standard or state-specific form to assess threats. Give you a few moments to fill that out. The other piece of making sure you do a fair threat assessment is considering more than just the threat, the statement, looking at the child, talking to people who know the child, see if we can find something that's happening with this student that's out of the ordinary, that's raising some red flags. Definitely take a deeper dive if you have a number of members of the team saying, yeah, something's going on here. We've noticed a change in behavior. That was true of TK. TK had really started to fall behind in classes and have more trouble at home and at school in the previous few months. So that could have been helpful if the family had reached out looking for more assistance, if the teachers had, reached out to the family and said, hey, we know TK is really struggling. Students are interviewed with threats. Here it says, ask whether the student will be interviewed and whether they can have an advocate or a trusted adult with them. Generally, the nature of these threats is real time. Schools can't wait, can't delay. The one caveat here is the the law in Ohio talks about teams being required for schools 6th through 12th grade, and that's pretty standard across the United States. We see these cases for younger and younger students. Every month we have younger students, 3rd graders, 4th graders. The younger the student, the more we should be concerned about having a trusted adult with our students to help them. And again, it's not just about the moment of the threat assessment, but looking at what comes next: counseling, behavioral supports. We know that we're looking in many cases, what's going to happen as a result of the threat. That might be suspension, expulsion, but really there needs to be more beyond that, beyond the exclusion. How do we support the student? How can they be educated if they are out of school and they are not getting services under their IEP or 504 plan as a special needs student? If they are just expelled, it is very likely that the school is not going to give them an opportunity to complete their schoolwork. So how do we keep a kid on track who might be facing expulsion for a long period of time? All considerations and all things that we should be asking in the immediate aftermath of a threat assessment when we're looking to support the student. Let's go to the next one. So PC is how not to do a threat assessment. PC and another young boy, 6th grade, were riding the school bus home. Noisy school bus, suburban district, and the students were making finger guns at each other across the school bus. PC has been in this district as a student since kindergarten. So this is his 7th year in the district. No known disabilities, no previous behavior issues. PC's family is able to get me 5 letters talking about what a great kid PC is within minutes. PC plays peewee football with a bunch of other kids. He's even coached younger students. And PC is a great kid who was doing this on the bus on the way home. I have watched the entire bus video. There are about 50 kids on the bus. I don't see or hear any of this. The bus driver obviously doesn't see it. But what happens is another student on the bus reports to their parent that boys were either talking about guns or playing like they had guns on the bus. That report is made after school to mom. Mom calls the school assistant principal and reports that children were talking about guns on the bus. You see here that PC, after this event, and the other student, we only represented PC. PC was suspended with a recommendation for an expulsion. This happened in, I believe, September of the school year, very early in the school year. And PC was also charged with a felony in the criminal court, the juvenile court down in Southern Ohio. We're going to flip right now to the next slide, which is going to show you the threat assessment that PC's school did for PC.
Ruth, this is your 10-minute warning.
Okay. Thanks, Danielle. This is a 3-page document. You all have heard me say that other schools will follow the CSTAG guidelines and do a 2-3 hour comprehensive assessment. Here we see 8, the big black box on the top left are 8 individuals. Those include 2 of PC's previous teachers from the previous years, the school resource officer and counselor, the assistant principal, couple others, maybe a intervention specialist who really didn't know PC. And these 8 individuals get together, they hear whatever it is that was reported to the assistant principal, which was that an unsafe comment about a gun was made on the bus, on the afternoon bus ride, and we see here September. So Okay, that's the information we have. That is the extent of the statement from the reporter. We see here antecedent to incident or threat. What happened before? Now, when they interviewed my student, he said they were just playing around, making believe they were shooting guns at each other. They were playing on the bus. So I would say the antecedent to the incident was playing. Access to materials mentioned in the incident. Did PC have a gun? We see here that it says no, and that's been confirmed by the sheriff. So the sheriff has gone out to this student's home and confirmed that this student does not, in fact, have guns, although he may have finger guns, but he doesn't have actual guns. And then, most concerning on page 1 here, we see that they have classified this as a high threat. Okay, this is a high threat. If we remember back to the beginning, that high threat, it is imminent. This is about to happen. Someone has made a plan. Someone is going to follow through with the plan. And unless we step in to stop it, this person will carry out their threat. We've rated it high, we being the school. And then we have these 2 other pages that we go through. We made these documents ourselves at the school, and we decide, what things are we looking at that are going to tell us a little bit more about PC and whether or not he truly has a plan in place, is motivated to carry it out, has a vendetta against somebody, is a violent person. And you see here, there's lots of different categories of personality traits. And the 8 people who gathered together said they discussed it as a team and decided that they didn't know this student. They didn't know PC well enough to definitively say he has any of these personality traits. Now, I'm going to remind you that PC has been a student in this district since kindergarten, and he's now in 6th grade. And 2 of these people were previous teachers of his. And then the last piece, the family dynamics, the team doesn't know PC well enough to comment on his family dynamics. It's just interesting to note that PC's dad was also a student in this district. So we're talking about a family who is long-term in this district and should have been very well known to this school. Bottom line here, bad threat assessment, inadequate work by the team, and a really unfair result for PC. Now, we were able to avoid expulsion for PC. He came back to school with an abeyance agreement. He was given an 80-day expulsion, held in abeyance after the first 10 days. And we spent 3 months in court until we were successfully able to get this case dismissed by the judge. The judge had no idea that this was the extent of the work the school district did. They take a 0 tolerance policy in this county. We have other cases in this county, and we know that to be true. We need to make sure that the schools are doing a good job so that this doesn't happen again for another student. This student and his family subsequently left the state, moved out of state after this happened. They were so devastated, and the parents said, if they are going to rate my child's finger gun as a high threat, I don't feel like they're doing a good job when there is a real threat. So we'll get to the key takeaways on the next slide. Again, schools have discretion. All they need to do is get a team together. All they need to do is make sure that team is trained and retrained. There is no form that any school has to abide by, but the ones available online through the CSTAG and the Department of Education are really comprehensive. Figuring out what level of a threat you have and whether that student needs to be removed from school is critical. Special ed students getting those extra protections and doing your research. So with that, I thank you. We're passionate about this. I probably have dozens more that I can share with you. We need to do a better job for our students when we're assessing threats and figuring out where the risk is and how we can support students.
Ruth, we have 2 questions coming in for you. One of them is cases where students have drawn a picture of a person with a knife and that the student is getting expelled for that.
Yeah. So again, this goes down to that interview, right? What was that person making a threat with that drawing? Have they talked to that student and said, what's this all about? It doesn't sound like a threat. We've had students who have been prompted to write scary stories. You'll hear about this one in my MDR presentation tomorrow. The prompt was to write a scary story for Halloween. And my autistic student wrote a scary story that involved Halloween type antics and used the name of a main character, and that name happened to be the name of his teacher. That was deemed a threat by that school. So again, getting to what's going on. Why'd you draw this picture? Mark is also going to talk about this when he does kind of our student perspective. Lots of things are deemed threats. We just need to figure out, is there an actual intent to do harm?
Thank you, Ruth. And then we have a couple of questions about attorney's fees or if there's a fee shifting statute related to our topics here today. Any comment on that?
Yeah, I think these last two are kind of similar. So I have had one case where a student did face some criminal sanctions and did incur a lot of attorney's fees, again, because our students have the right to be represented by court-appointed counsel. Sometimes that would be trickier if parents go ahead and hire an attorney. We do have one case where our students should not have faced criminal charges after a threat assessment. And that family, we were successfully able to get them the fees for my services related to the criminal representation covered. Sometimes we, I have a bleeding heart, and for PC, that was an awful lot of legal bills for that family to endure, for us to champion them. I wish it wasn't so expensive, and I wish the school would be made to account for some of those fees. We don't do that unless the family is asking us to do that. We have another one currently active that has some due process components that also involved criminal representation, and we will be seeking their reimbursement for any criminal representation in that matter in our due process, along with our claims for the violation of FAPE.
Thank you, Ruth. We're waiting on some other questions to come in. Are there any other cases? I know you've had a lot on this topic. Is there anything else that comes to mind?
I can share a couple others. Not sure if we talked about this one last year. Again, speaking to the requirement for the threat assessment team to be in schools with 6th through 12th grade. We had a 3rd grader who used not an Apple Watch, but some sort of watch that enabled him to make phone calls to his parent, his grandparent. He wore that Apple Watch all the time, and he did have some communication disorders. He saw his teacher's phone number on an assignment, a homework assignment, call me if you need help. And our little 3rd grader used his wristwatch phone to call in a threat of a nuclear bomb. So this is one of those cases where even if we used that really poor threat assessment at the end, I'm pretty sure my student did not have access to nuclear bombs. There was no way that he posed a threat to the school, given that he had the communication disorder. That also kind of helped his case. His youth helped his case. Obviously, there were no criminal charges filed there, but it's not a big stretch. If this happened in the county where PC was charged, he likely would have been charged even as a 9-year-old.
Thank
He
you so much,
was
Ruth, for
shortly
sharing
expelled.
expertise with us. Thank you for sharing all your expertise with us today. It looks like we actually took it all the way to the end of the session.
Perfect. Yeah, thank you so much, Ruth. That was a great presentation. I know that you are passionate about this topic, and you've had a lot of good cases that really display what's been going on across the state and really representative across the United States as a whole. So thank you so much for that. Of course, if anyone has any questions that they didn't get in time in the Q&A, we will be holding our attorney advocate panel at 4 o'clock in just about 8 minutes after our break. Elizabeth did drop an evaluation in the chat, so if you could please fill out the evaluation, we value your feedback, and we will be back at 4 o'clock this time.
Thanks, Ruth.